Trouble started when the National Assembly threatened to veto the refusal of the President to sign the Fourth Amendment of the Constitution into law. The Attorney General and Minister of Justice then approached the court, which in turn granted an order urging parties to maintain status quo. The reason for the refusal of the President to assent to the bill is that 10 out of the 65 amendments were not good laws and should be reworked. Some of the issues contended by the President includes Section 59, which gives the National Assembly powers to pass an amendment bill into law if the President withholds his assent in 30 days. The President is also contesting Section 84, which the lawmakers altered to include a new subsection which sought to give the Senate President, the Speaker of the House of Representatives, and their deputies pension for life at a rate equivalent to the annual salary of the incumbent principal officers, provided such a person is not impeached. Others include the appointment of the Attorney General and the Accountant General of the country, which were at the discretion of the President. The amendment has prescribed that it be carried out only after the input of certain organs of government. However, the case could not proceed as the court disagreed with the counsel to the executive and motioned to substitute the plaintiff from the Attorney General to President Goodluck Jonathan. The court observed that the originating sermon is defective because the deponent to the affidavit swore on behalf of the Attorney General of the Federation and not the President. The counsel to the Attorney General was thereafter advised to withdraw the suit and either approach the court afresh or, in the alternative, explore an out-of-court settlement. On his part, lawyer to the National Assembly asked the court to vacate an earlier order asking all parties to maintain status quo. The court, however, asked him to give an undertaking on behalf of his client that status quo will be maintained while an out-of-court settlement is explored. Having agreed, the 7-man panel led by the Chief Justice struck out the suit and ordered parties to explore an out-of-court resolution.
If you look at the amendment proposed by the National Assembly, they proposed to amend 65 sections of the Constitution. The only areas we're complaining about are 10 out of 65. So, I mean, it's almost next to nothing. So I'm sure, as the court pointed out, when the two parties sit down, they can iron the gray areas.
I am exceedingly glad that the Supreme Court has responded, as fathers of the nation by saying, let there be peace. And I think the best legacy, the best gift the President and the 7th National Assembly can give to Nigerians is resolution of this issue amicably so that we can have, a new amended or alteration of the Constitution.
The court adjourned the suit to Wednesday, 27th of May, for the report of settlement of a further hearing. Amaka Okafor, Channels Television News.